Hello. Thank you very much. That the clerk offers. Wealthy people and folks with a lot of assets, they have their assets in trust or have transfer agreements, and a lot of that generational wealth easily passes to the next generation. But for the middle class and the rest of us, some of that generational wealth sometimes gets lost when it transfers from one generation to the next. So this is a really great program that Clerk Yarborough has set up to make sure that that generational wealth is not lost as we in the middle and the rest of our economy. So I really appreciate everyone who's come out tonight. I really appreciate the employees of the clerk's office who've stayed beyond their normal work hours to provide this presentation, to make sure that everybody's questions are answered, and to provide what's a pretty valuable service. We have legal aid over here today. They'll answer any of your general legal questions. We have Jim Gleffy, Kang, and Theodore London, who are going to answer some of your questions about transfer on death. Kang and I used to work together at the county office for a few years, and Jim was very generous enough. For those of you who record at least 10 documents in a year, you get the Jim Gleffy hat, which I just want to say, if you wear this in the neighborhood, people will know who you are. So I want to thank you, Jim, for being so generous.
It's a very hot commodity, I must say.
Yes.
Thank you, Pat. And thank you, everybody, for coming tonight. I know it's a beautiful evening. Thank you, guys. My name is Brian. Cross. I'm the Director of Veteran Services for the Cook County Clerk's Office, Karen A. Yarborough's office. And on behalf of Clerk Yarborough, we want to thank all of you for being here this evening. We also want to thank our host, Pat Hines. Pat and his staff have been great to work with. Carrie Bernardini, Irene Farbo, they've been rock stars and just great to work with and great, and to bring a great crowd here tonight. And to reiterate what Pat said and to add a few more, we want to thank our staff for being here. Jim Gleffy and his wonderful hat, Kang, Ted London, who's a great attorney and is going to provide a lot of great insight this evening. I also want to thank some of our other staffers for joining us this evening. From our Director of Communications, Frank Herrera, please wave and when you're set. Hernandez. From Human Resources, Don Sloan. Deputy, as I said before, our Deputy Chief of Staff Legal Counsel, Kang Trin and Ted London. And also from our Elections Department to help you if you have any questions with that or on property, Kevin Drake and Yolenta Adamczyk from our Elections Department. Again, we want to thank our guests for coming. We're going to go over a few household items, and then we're going to get started right up. The restrooms are located right up this set of stairs. Just go straight back. There's a door behind us. Also, please silence your cell phones for this presentation. Thank you. And I'd also be remiss if I didn't thank our colleagues from Legal Aid Chicago. They've been a great help to us. Barbara Servin and Melissa Bartolome from Legal Aid Chicago. I know that I came around and everybody has their index cards. You can take notes, or also, more importantly, at the end of the presentation this evening, we're going to do a question and answer session. So we'll come around and collect the cards, and our legal staff will be more than happy to answer any specific questions you have. We hope you find this information today useful and will use it to aid your friends, your family, and your neighbors to protect your property. So on behalf of Clerk Yarborough, we again want to appreciate our community partners to bring you this information. If you just give us a second, we're going to set up the video for your information tonight.
Hello and welcome. I'm Karen Yarborough, your Cook County Clerk. Thank you for joining us for this presentation on property fraud and managing your property after death. The Cook County Clerk's Office is one of the largest consolidated clerk's offices in the entire nation. In addition to functioning as the chief election authority for suburban Cook County, we maintain birth, marriage, and death records, and we assist property owners in redeeming delinquent taxes. We also have a recording operations division that records and stores land records and other official documents, which includes deeds, transfer on death instruments, and real estate documents. Now, nobody wants to talk about death or end-of-life planning, but it's a critical issue when it comes to managing your assets to protect your family and your loved ones. And we all need to be aware of the threat of property fraud and how we can guard against this type of financial crime. At the Cook County Clerk's Office, we are here to serve, and we hope that this information you received today will be helpful on these important issues that impact all of our daily lives. Now, I'd like to introduce you to my trusty assistant who will guide us through this presentation.
Thank you, Madam Clerk. Before we begin our discussion, we want to let you know that we will have volunteer attorneys available at the end of the presentation who can answer your questions about the topics we will be covering. If you are joining our program via Zoom and have questions that come up during the presentation, simply type your question in the Q&A section through your Zoom link and the attorneys will respond accordingly. Now let's begin our discussion by talking about property fraud, which can also be known as deed fraud. So, what exactly is property fraud? Property fraud is the fraudulent and illegal recording of a document against your home's property records. We call it paper terrorism, and it is a very real problem and potential risk for all property owners. How can this happen? Almost every state has an open and public recording system, meaning that you cannot freeze your chain of title like you can your credit report. Plus, county recorders are not authorized by law to validate legal claims made in documents. Property fraud can involve the recording or filing of false or forged transfers of ownership, quitclaim deeds, or the filing of a bogus lien to steal property or harass an unsuspecting property owner. Even if your home is paid off, that does not stop someone from filing a new deed on top of it without the property owner's knowledge. Let's look at this NBC5 investigative report that takes a close look at how property fraud can occur.
By law, it is a line anyone can stand in and a fee anyone can pay. $40 is all it takes to get a deed or other document officially recorded in Cook County. A simple perk of open government openly abused by serious scammers.
I think they call them, financial parasites.
She was new to her office as recorder of deeds when Karen Yarborough says she first spotted the trouble.
To steal a home, all you have to do is doctor some paperwork up and Photoshop it, bring it to the recorder's office, record it, voila, you own a home.
Con artists exploiting a system that relies on the honesty of those who use it, recording forged documents in order to steal a home outright. Sound far-fetched?
This is a kind of crime that I never imagined that could happen.
It did to Chicago Treasurer Stephanie Neely until it happened to her.
When I get this call, I'm like, what do you mean someone has changed the name on my deed? What do you mean? How do they do that?
In her case, a stranger recorded a fraudulent deed, waited until she was at work, and then changed the lock.
They want to physically be in your house, because once they're there, it's very difficult to get them out.
Precisely what happened to this Chicago woman.
This individual had paperwork that was Xerox that showed the deed was in his name.
She asked us to conceal her identity because
you're in constant fear that they will try something next, because believe it or not, they did come back 3 days later.
One man connected to her case was arrested and convicted. As the recorder's office continued to field fake documents,
I decided that I couldn't sit idly by and watch this happen.
Yarborough brought in this man.
They believe that the government created artificial duplicates of all of us.
An expert on sovereign citizens, the extreme anti-government movement often behind this crime.
They believe they can completely ignore our government and do whatever they want to do with impunity.
Pitcavage calls it paper terrorism and teaches the red flags, like the punctuation sovereigns add in the middle of names, the refusal to use mainstream addresses or zip codes, and how they employ lengthy, arcane terms. The flurry of documents they file may be fake, but their threat is real.
They're bullies. They're brazen. They think that nothing can touch them.
A lot of times they'll come in and overwhelm our frontline staff. You know, it may be 20 of them will come in.
Yarborough has a catchy comparison she uses to get a non-believer's attention. In Illinois, it is easier to steal a home than it is to steal a car.
It's fraud and, you know, they're taking people's homes.
So there is now a simple way for some homeowners to protect themselves, the free property fraud alert system. You load your property index number, then you get an alert if any document is recorded in connection with your property. Counties across the country are now turning to this kind of system as these cases of mortgage and property fraud continue to grow. Lisa Parker, NBC5, investigates.
To combat this problem, Clerk Yarborough created a property fraud unit with investigators and caseworkers who respond to and investigate any complaints of property fraud. The clerk's office also offers a free property fraud alert that will provide a telephone call or email to the property owner anytime a document is recorded against their property or the property of a loved one. There are 3 easy ways to sign up for the clerk's free property fraud alert. You may sign up in person at the clerk's office, sign up online, sign up with a telephone call. Once registered, if you receive an alert or have reason to be concerned about property fraud, you can contact the clerk's property fraud unit and our staff can help research the problem and coordinate a response. Call 312-603-4000 or visit our website at www.cookcountyclerk.com/property fraud. On a related note, while we're on the topic of your chain of title and fraud, property owners often need to obtain an official copy of their property deed when purchasing a home or for tax purposes. You should be aware there is a predatory practice aimed at homeowners in which companies offer a copy of your property's deed at a large markup price, sometimes exceeding $200. The clerk's office wants to remind you that we offer the same service starting at just $6. So there is no reason to pay exorbitant prices to gain access to these essential documents. Now let's move on to the second part of our program, which is making plans to manage your property and assets in the event of your death. As Clerk Yarborough noted, no one wants to talk about death or end-of-life planning, but it is critical to manage your assets to protect your family and loved ones. Having a sound end-of-life plan is one of the greatest gifts that you can provide to your children and family members. Consider this. What do you think of these 3 legendary individuals have in common? Prince, Aretha Franklin,
87 years ago, our fathers,
and Abraham Lincoln. Actually, they have something very unfortunate in common. They failed to make plans for their assets upon their death. No will, no trust, no plan. Now let's consider someone who thought he had it right. Music legend James Brown, the godfather of soul. When he passed away in 2006, Brown's estate was worth an estimated $90 million. When he died, Brown left behind a plan for most of his estate to pay for scholarships for children in need in South Carolina, the state where he was born. But that will was challenged by family members after his death, resulting in more than 12 lawsuits. It took more than a decade of litigation before Mr. Brown's assets were designated as he had intended. So how do you get it right when it comes to your property after death? The best advice is to consult an attorney or an estate planning professional to provide you with advice for your specific circumstances. But you should also know that under Illinois law, you can transfer your home, your car, or your bank account to a loved one without a will or trust and without having to pay fees or court costs. Here are the details on how to transfer your property. First, the transfer on death instrument. The clerk's office offers a free document on our website known as a transfer on death instrument, or a Toady. You can also obtain this document at no cost from an attorney or legal aid organization. The form should be completed and notarized and then recorded at the clerk's office in our recording operations division. The transfer on death instrument will then be recorded on your property's chain of title. And upon your death, the person designated to receive your property can do so after completing the required forms. Please note that the clerk's office cannot assist you in the preparation of the transfer on death instrument or any legal document, and we do not provide legal advice to customers. Next, let's discuss a payable on death instrument. You can transfer the funds from your bank account in a similar way, utilizing a tool known as a payable on death instrument. A person can transfer assets in a bank account to a beneficiary of their choosing after death. A payable on death instrument can be obtained and used at most financial institutions for checking and savings accounts, certificates of deposits, CDs, money markets, and savings bonds. Even if you have completed a payable on death instrument, the account holder has full control of their funds in the account until the time of their death. When the account holder passes, the beneficiary can claim specified assets directly from the financial institution without having to wait for probate court proceedings. Finally, let's discuss a beneficiary affidavit. And lastly, there is also a mechanism to transfer your car to a designated beneficiary. A vehicle owner may change, add, or remove a beneficiary on the title of their car by completing a free beneficiary affidavit through the Illinois Secretary of State's office. To obtain this beneficiary affidavit, go to the Illinois Secretary of State website at www.ilsos.gov. Keep in mind that if money is still owed on your home or vehicle at the time of your death, your beneficiary will still be responsible for the mortgage and payments moving forward. On behalf of Clerk Karen Yarborough, we hope that you have found this presentation useful. The clerk's office is your first line of defense against property fraud, so we hope that you will take this opportunity to sign up for our free property fraud alert if you have not already done so. Managing your property and your assets in the event of your death is also critical to protect your family and your assets, and to ensure that your wishes are carried out after your death. A copy of this presentation is available on the clerk's website if you would like to review it again or share with a friend or family member. Go to www.cookcountyclerk.com/PAD resources to view the presentation. Now let's ask the volunteer attorneys who are joining us to introduce themselves, and we will open up our presentation for your questions.
Okay, so the first question I have here, it says, I have one son listed on a joint savings account and one son listed on a single savings. Do I need to complete a payable on death form at my bank? Okay, sorry. So the question is, do I need to complete a payable on death form if the sons are listed on the accounts?
So, good evening. My name is Ted London. I'm a private attorney. I handle estate planning and probate matters. So I'll answer some of your questions. So that question is, if you have someone's name on your account as a joint account holder, do you need to add beneficiaries? And the answer is no. If you have someone's name on your account, your children's names on your accounts, you do not have to have beneficiaries, because respectfully, once you go to heaven, then if the child's name is on the account, then they'll be able to access the money. Here's a thing though. I never encourage my clients to put their children's names on their accounts. because I've seen horrible things that children and grandchildren have done to their parents. So you're going to be better served to just to have your children or grandchildren as beneficiaries, so they don't have complete access to your account while you're living. If you have your children's names on your accounts while you're living, if they are sued, the collections can actually go against your account that their name is on. I never advise my clients to have their children's names on their accounts. You want them to just be beneficiaries, and that will keep the money out of probate court once you go to heaven, if you will. You know what? Here's what's interesting about banks and some of the customer service people that you will encounter at some of these banks. Unbelievably, they provide misinformation. I've seen that so often. So what that banker associate told you is absolutely untrue, and it's not correct. If you have a beneficiary on your accounts, then whomever you have named as the beneficiaries, and again, you can name all the kids or just the good one, that's up to you, and they'll get the money very easily once you go to heaven. And let's be clear about the power of attorney part of her comment as well. Power of attorneys are only good while a person is living. So once they pass away, they are void. But it is untrue. If you have beneficiaries on any of your financial accounts, checking, savings, mutual funds, 401ks, stocks, bonds, CDs, credit unions, life insurance policies, annuities, then whomever the named beneficiary is will get those funds very easily once the person goes to heaven, but they will not have access to the accounts while you're living. That's what I'm opposed to.
And I just want to provide a little bit of a story just to illustrate the point that Attorney London made about having someone on the account. Sometimes it's not necessarily a nefarious or bad intention that causes problems when you have someone on your account. When I was in college, I had a new checking account. My mom had opened the account in our joint names because she wanted to be able to access it if she needed to. Little did I know, that she had some creditors that were interested in, collecting something that she owed them. Now I got my student loan money from the university. I paid most of the cost for the year, and whatever was left over was to go into my account so I could, pay for my living expenses. Well, the creditors didn't care about that. They took the money. And I tried to get the money from my account, had no money left. And I asked my mom, she had no idea what had happened, but they just went to the bank and said, this person's on this account, they owe me money, and they took it. So the reason why I bring that up is just to give an example of some problems that can be caused by having someone on your account without necessarily any bad intention. That's why the payable on death accounts are so important. You can actually designate someone to be able to collect the money if something happens to you without putting the risk out there for them, subjecting you to their creditors. So I just wanted to tell that.
You know what, may I just add with respect to what Jim said? Like he said, sometimes these things occur where, it's just, his mom didn't know that there was an outstanding creditor. But I'll tell you, more often than not, I've seen where the children and the grandchildren whose names have been on the accounts have taken huge sums of money from their parents and grandparents because they have access to the accounts because you put them on your account. So I am absolutely 100% adverse to you adding your children's names to your accounts. Now, of course, our clients know their children better than I do, but sometimes you may not know them as well. So please be mindful of that.
Before we get to the next question, I just want to mention that someone had lost this in the parking lot. It looks like a little brown purse. So I'm going to, can you give this to Brian? And Brian could validate that that is the correct owner. I understand she wouldn't. Sure.
They are one and the same. They are one and the same. Well, that can't be on the same account. You can't have a payable on death and a beneficiary on the same account. Some banks or institutions, they name them, they title them payable on death. Others title them beneficiaries, but they are one and the same. Yes.
So the next question we have, and I apologize if I have a difficult time reading the handwriting. Beneficiary form. Okay. If I die, can my daughter get my something automatically on the, she have to have this affidavit form in her possession. I really can't read it. Yeah, I'm going to go to the next question. I'm going to ask Brian to see if he can determine what that says. Okay, the next question. Both parents have passed, and my name is on the bank accounts. Should I close the accounts out and have my name removed from them?
Okay. If your names are on, if your children's names are on your accounts, when you pass away, it is your choice to access the money and close the account. But the fact is, you are already the account owner. So you can keep the money in the account, write checks from that account, deposit money in that account, withdraw money from that account because you are the owner. Once you add someone's name to your account, or if your name is added to someone's account, once one of those persons pass away, then survivors are the owner of the account. So the person that asked that question, do you need to close that account and remove the money? That is your choice. You can keep it in the account because you are the account owner, or you can take it out of that account and transfer it to another account.
Okay, I think I figured out with Brian's assistance what that original question was. So it says, if I die, can my daughter get my car automatically, or does she have to have this affidavit form in her possession and give to the Secretary of State?
Well, that brings up even a broader issue. The issue is oftentimes what we see in our office is if a family only has one child, they think that that child is entitled to all of their assets. And even if there is no estate planning, and the fact is that is true. If you have one child, when you go to heaven, that one child is going to be entitled to the real estate. They're going to be entitled to the money. Because typically when people go to heaven, those are really the only two issues that they're dealing with. They're dealing with the real estate and the money. They're not fighting over that 30-year-old Fox stove with the face still on it that my grandmother used to have. Okay? They're fighting over the real estate and the money. So if there's only one child, they're going to be entitled to it. The issue is, how are they going to get it in their name? Well, if it's the real estate, if you don't have some estate planning, then they're going to have to go through the probate process. If it's money, then depending on the amount, they may have to go through the probate process as well. If it's a car, yes, you're going to need the affidavit from the Secretary of State's office to get that car transferred from the name of the parent to the child. But just because you have one child doesn't keep your things out of probate court if you don't have some estate planning. They will be entitled to it, but they're going to have to go through the probate process to perfect their interest in the financial accounts or the real estate if you don't have some estate planning.
Okay, here's a informational question. Do you need to go downtown to filing records, or are there other locations? I can answer this. Generally speaking, there's only one location where you can file documents for recording, and that's downtown at 118 North Clark. But there's different methods for you to get it to us. So you could either mail the document to us, or you can, depending on the type of document, have a company e-record that document for you. E-recording is probably 80% or more of the documents that we record now, and especially if you get the document prepared by a title company or another entity that has a bulk agreement on file, they'll be able to do that electronically. If you don't, that's not a big deal. We have a process where mailed-in documents can be recorded as well for a small mail-in fee. I think it's $5. So if you have questions about how to mail the document to us, we'd be happy to answer that. after the presentation. Really briefly, it's our office location is 118 North Clark, room 120. So if you're mailing a document to be recorded, make sure you include your form of payment in the with the document as well. Next question. And this is specifically for Mr. London, it says on the card. With multiple beneficiaries, if they are listed as number 1, number 2, and number 3, do they all have to sign, or if all listed as number 1 or 2 or number 3?
Well, so the question is, if there are multiple beneficiaries on the account, I presume the question is, how will they collect the money? Well, to be clear, if there's multiple beneficiaries on the account, the first important point to note is that beneficiary is only going to be able to collect their portion of the funds. They're not going to be able to collect all of the funds and distribute the funds to the other 2 in this case. So if you have 3 named beneficiaries on an account, they're each going to have to go and fill out a claim form to collect their portion. Now, it's a distinction between having multiple beneficiaries on accounts and having successor beneficiaries on the accounts. You can have one beneficiary, and then if that person passes away, then you automatically have a secondary person. So there's a distinction between having 3 beneficiaries and successor beneficiaries. If you have 3 beneficiaries, each one of them will divide the money equally. If you have successor beneficiary, if one passes away, then the money automatically goes to the successor.
Okay. The next question, and I'm sorry if I'm going through this, we just have a lot of questions. I want to make sure everyone has their question answered. The next question is, if somebody lives in another county in Illinois, does the Toady get recorded in their county? And the answer is yes. You'd record the document in the county in which the real estate is located. If the property's in Will County, it makes no sense to record it in Cook County because your chain of title is not recorded in Cook County, it's in Will County. So wherever the property is located, that's where you would record the transfer on death instrument. Yes, Toady is a state statute. It used to be the residential real estate transfer on death instrument, but now since 2022, it applies to commercial real estate as well. The next question. Okay, can a whole life insurance be an effective way to protect assets from estate taxes? Do you think that the current estate tax will sunset and estate taxes go back up?
Well, so question is about whole life insurance. Some people don't know what whole life insurance is. Whole life insurance is a policy that accumulates cash value that typically a person pays for an amount of time. And then you name a beneficiary on the death benefit, or you can actually borrow against the accrued value of the life insurance policy. That money, when it's payable to your named beneficiaries, is tax-free. There is no taxes on life insurance policy. And the last I checked, the tax rate for an estate tax, I think, began at about $16 million or so. So that was the last time I checked. It may have fluctuated since the last time I've checked. And so typically up until this $16 million point, there are no estate taxes. But there is no estate taxes on life insurance and death benefits. You know what? It's taxes are really an accounting issue. And so because there's a lot of complexities with taxes and depreciation of assets and value of assets, so that's more of an accounting issue really than a legal issue.
Okay. The next question, is there an advantage to using the Toady? No, scratch that out. Is there an advantage to using the payable on death instrument instead of naming a beneficiary on your savings, CDs, or other accounts? I think Mr. London already said that they're basically one and the same, beneficiary or just a payable on death account. There's no, they're the same exact thing. The next question. if somebody does deed fraud, does the person eventually get their home back? King Trin, our attorney here, actually manages the property fraud unit in our office, so I'm going to turn over to him to answer this question.
Well, it depends. It big depends, right? Because it doesn't automatically happen. If somebody comes in and records a deed against my property, and if I'm not signed up with the property fraud alert, and it's not, it might be a misnomer. You get an alert if you sign up. You get an alert when you sign up. You can sign up for either getting an email or a phone call. The only other way to know is to familiarize yourself with the website that we have. And our website, you can search your chain of title. You can do it whenever you want to, how many times you want to. It's free. Free to search, and then also free to view a document that's recorded against your chain of title. And that's really important to know, because time and again, I've had taxpayers yourself visit various websites, and they actually end up paying a lot of money for these private companies that sell the same documents that we have, and we have them for free. So keep that in mind when you go online, check your chain of title, that you have a family member maybe if you're not familiar with how to use the internet, a loved one, grandchildren who are familiar with using the internet, and then go to our website, punch in your property index number, and then have a look. It's important for you to have a look. And so you've got two tools. One, you sign up for the property fraud alert, so you get an alert when there's a document that's recorded against your property, and then also familiarize yourself with how the website works. It's really important. And so what happens is that when a document gets recorded, remember, by state law, our duties are ministerial. That means if a document has all the basic recording requirements, like a PIN number, a name, a legal description, it doesn't even have to be accurate. That will get recorded. And if you've signed up, you get an alert. And if you see something like, hey, there's a quitclaim deed that's recorded against my chain of title, give us a call. And we'll look at it and we'll help you out.
And just kind of getting back to the nature of the question, if there is fraud, deed fraud, like how do you get your property back? So the way it works is if the deed is recorded in our office, on paper, the person who filed that could be the owner of the property. Now, there's different ways where you can get that taken out of the chain of title. One, you could file a private lawsuit called a quiet title action that would bring it before a judge and say, hey, this deed was filed, it's fraudulent. The judge can order that the deed would be void and removed from the chain of title. Another way we can handle that is we have a property fraud unit in our office. Our investigators can bring administrative actions with the help of the Cook County State's Attorney's Office to take a case against the person who filed the document. The state's attorney would represent us in court and ultimately invalidate that document. A new document would be recorded in that place saying this document is void, it was subject to fraud. So, the concept of someone stealing a home is kind of abstract, and it's not like you can pick up a home and put it in your pocket. But on paper, you want to make sure that when someone goes to look at your chain of title, that it reflects your name if you're the owner of the property. Because when you go to refinance or you go to sell the property and they see that someone else's name is there, guess what? No bank is going to underwrite a mortgage for someone buying your property if it says that you don't own the property. So that's why this is important. We want to make sure that your chain of title remains clean, that you are the record owner, and that you can transfer the property however you deem fit.
One thing just to reiterate too, when my colleague Mr. Trin was talking about the property fraud alert, that's one thing that we can do tonight. And we encourage you, before you leave, to come over to the table on my right and sign up. Because as King said, it's extremely, extremely important that it's helped save many, many people's property. So.
CookCountyClerk.com. Yeah, if you ever have a question about that, our fraud unit would be more than happy to walk through that with you. And the phone number to contact our fraud unit is 312-603-4000. We have investigators on staff that are more than happy to talk to homeowners and go through their chain of title with them and explain to them what's on there. And this is a related question, a follow-up. How does fraud alert on a house work if you're getting notice after the document is filed? So I know the thinking of that question is that, hey, if the document's already filed, they already took my house. But as I mentioned, there's different ways to address it. You could either file a private lawsuit to quiet title, or you could contact our office and we can institute an administrative action to get that document removed from the chain of title. A lot of times, you know, the people that are committing fraud, they don't necessarily want to be in your house. They want to be the record owner so that they could defraud a bank or take out a mortgage on the property and take the proceeds away. So yeah, I know the video kind of alluded to the fact that someone could actually steal the house, and I use the analogy like putting it in your pocket. It can't do that, but on paper they can do it, and that's one of the reasons why they would do it, because there's another reason behind it, such as trying to take out a mortgage and take the proceeds and going and doing whatever they want with it.
Just as a clarification, sometimes the questions, the intent behind it may be asked that, hey, why can't it work like a credit card freeze? So, right, everybody's familiar with credit freezes. And sometimes there are products out there that you see on TV, they promise a chain of title freeze. That's not how it works. So the Cook County Clerk's office at the recording operations, and I think I mentioned that before, our duties are ministerial. And by state law, the way it works is that we don't get to question the legality of a document when it's getting recorded. Similar to a library, right? You take a library book, you look at the card catalog number, and you put it on the shelf. And that's what you imagine our office does. We just take a book and then put it on a shelf. And that's why it's so important to make sure that you fill out the property fraud alert so you get signed up.
You could call the fraud unit and they can check if you signed up. Yeah, it's.
You can sign up again. You can sign up multiple times. It's okay. You know, if you forgot, you just sign up again. You know, sometimes if you want to, you sign up for yourself again. And then say the children want to help you, they can sign up as well. So multiple sign-ups doesn't matter.
Or you could call our fraud unit at 312-603-4000. They'll be happy to up to see if there's an account, an alert on file. Okay. Next question. If you are an executor on an account, the state has been settled, and 2 years later, there is a settlement against for something with stock. I'm sorry, I'm having a hard time reading that one. How do you distribute money from the settlement since the bank account has been closed? Does anyone recognize asking that question? Can you elaborate a little bit?
So what her question is referring to is if someone passes away and they either have a will and the will has to be probated, or there is no will and the estate has to be probated. And well, again, so then I was just giving the people some background information. And so if there is a probate matter, then there is an administrator or an executor named, and they distribute the money to whoever the ordered heirs are. Now, if there's money found subsequent to the estate being closed, then the estate would have to be reopened, and then administrator named, and the heirs would be distributed that money. So if the estate is not closed, it is just part of an open estate. You would just disperse the money. If the estate has been closed, then yes, you have to reopen it because the executor or the administrator must get access to the money And the only way they're going to be able to do that is if they are the named court-ordered administrator or the executor.
Okay. This is a good question that I think a lot of people have on their mind. If a successor or beneficiary is a minor, does a trust have to be created?
So that's a good question. So one cannot leave money or real estate to a minor. If you leave money to a minor as a beneficiary on your account, they are not going to be able to access the money. People love their grandchildren, and sometimes they're more concerned about leaving their grandchildren money than even their children. But if you're going to leave money to your grandchildren, you have to do it by way of a living trust. And what that does is that allows you to name someone that's going to manage the money for the minor, and you can have very specific details on what conditions the minor must meet to be entitled to the money. Graduate from college, get married, don't get married, whatever your conditions are, then that minor is going to be entitled to the money. Sometimes when I do living trust for my clients and they want to leave money to their grandchildren, typically it goes something like this. We're going to give them X amount of dollars per year for college. Typically I give them up to 5 years. And then typically we'll give them a certain amount of money when they graduate from college, maybe a certain amount when they turn 25, maybe another amount when they turn 30, and maybe the balance when they turn 35 years old. Okay, so we don't give them all the money at one time. We give them money in increments. And then those increments can be any condition that you literally set for them. But if you leave the money, minors, as a beneficiary on your financial accounts, then what's going to have to happen is their parents or a loved one is going to have to go through the probate process to be appointed their guardian. And then the guardian then will only act to collect the money, and the money will go into a minor's account until the minor turns 18 years old. And so at 18 years old, the minor gets all this money. By 19, they're broke. Okay? Not to mention, the parent or the guardian is going to have to pay the lawyer a handsome sum to go through the probate process just to collect the money to put it in an account that the minor is going to get it all when they turn 18. Not a prudent way to leave money to minors. Okay?
Quick, so you talked a lot about leaving money back to minors, but what about real estate?
Likewise. And so typically when we do estate planning for our clients and they want to leave real estate to minor children, we will put it in some sort of trust for them, either a land trust or a living trust. And again, we name what's called a trustee for the minor that's going to manage the property for the minor. We will give some instructions in the trust on how the property should be managed. Should it be sold? Should it be managed until the minor turns 18? But it's going to keep the property out of probate court as well. So if you want to leave money or real estate to a minor, you don't want them to be beneficiaries on a financial account of any sort, nor do you want them to be the beneficiary of a Toady or any other transfer document for real estate. You're going to need to leave the minor's real estate or money through a living trust to keep it out of probate court and keep the expenses down for your family members who are going to need to manage the financial resources or the real estate for the minor until they turn 18 years old.
That's a very
What was the first one? I don't understand that, to be honest with you, either. But I can give you some information. There are a number of kinds of trust. And so trust, there are living trust and there are land trust, and a number of other kinds of trust as well. But the primary benefit of having a living trust, a land trust, or a variety of types of trust is it's going to keep your real estate and your money out of the expensive, time-consuming, stressful probate process. Really, when you talk about estate planning, that's really should be your objective, is to avoid probate court. Again, that's expensive, that's complicated, it's stressful. Family members are fighting there and lawyers are doing well there. And so really the way to avoid that is to set up a trust while you're living. And the type of trust that you set up, whether it's a land trust or a living trust, is really predicated on what you're trying to accomplish. So you need to talk to your lawyers, have some idea of what you want to accomplish with your real estate and your money after you, and then they can help you figure out what type of trust you may need to help accomplish your objectives. No. So the question is, if there is money left to a minor by way of a beneficiary on a financial account, and a guardian is appointed, what happens to the money? What happens if the guardian takes the money? Well, this is part of the process of being appointed as a guardian for a minor. When you move in to collect money for the minor, the court's going to make you get a bond. So there are going to be more fees associated with the process of being appointed as the guardian for the minor. And then once the bond is had, that's an insurance policy. In the event that the guardian does misuse the money, the bond insurance will then pay that money back and then sue the guardian. But the child will be made whole. But the money's going to go into a court-guarded account. That means once that money is deposited into the account, no one can access that money, even for the benefit of the minor child, without a court order. Okay, and then that guardianship matter is not closed until the court is assured by way of a document, an account document stating that this is a court-ordered account, and then no one in the banks is going to allow any money to be withdrawn from that account, even for braces, gym shoes, tuition, health care, without a court order. If you have that money in some sort of trust, then you're going to name someone that's going to be able to manage that money for that minor child, and they're not going to have to go through the expensive court process to get in a position to care for the minor. If you have a minor and you need someone to care for them because of a catastrophe, someone passes away, there are funds to raise a child, and someone may need the money. And so the best way to leave money for the benefit of a child, even while they're minors, if someone is going to be caring for them, grandparents likely, is to leave the money in a trust so the grandparents can have access to the money to care for the child all along the way.
Okay. This next question is a very common question that we see. And it's not in the question, but it's presumed that there's a home involved. Parents both deceased, and there was no will or trust. There's 5 children. One of the children is still in the home, and that person is trusted. How can we get him on the home as an owner to keep it and maintain it and possibly sell it later? Unfortunately, if you pass away and you don't have a will or a trust or some other document, it's going to have to go to probate court.
You know what? That's a universal question. I've been practicing law now for 25 years, just this year. I know I don't look like I could have possibly been practicing for that long, but it's been a short 25 years. And here's what I've discovered in that 25-year time frame. If you have at least 3 children, one of them is going to be a problem. That's just typically my rule of thumb. If you have 4 kids, that means you have 1 1/4 problems. And oftentimes, it's the child, respectfully, that may have some substance abuse issues, underemployed, that really monopolize, in this case, the real estate. And so if a person passes away, if they have 5 children, that's the case I don't necessarily want to see it in my office because it's going to be kind of a headache. And so then the lawyer is going to have to bill you for that. Okay? But the bottom line is going to have to go through the probate process. All of the children are going to be entitled to equal shares. And then you're not going to be able to really evict the one who's living in there. You may be able to get a court order to compel that person to pay rent and then take that rent for the time that they've been in the home from their share, more legal fees all along the way. Okay? So the way to avoid all of that is to do some estate planning while you can. And that's going to avoid the probate process. That's going to avoid the expensive legal fees. That's going to avoid the confusion with your family. And you know your children better than the lawyer does. You know who's going to cause a problem. And so you want to avoid that. And you can by doing some estate planning.
Okay, here's a question. I've heard that a bank account is frozen on the death of any owner. Even if your child or spouse is on the account, it is still frozen. Is that correct? And how to avoid this? if that is correct.
Well, this is another case of frontline bank workers giving misinformation. We see this practically every day. I don't know what's going on in these banks, but they are giving misinformation. If there are multiple people's names on an account as owners, husband and wife, for example, if one of the spouses passes away or one of the three passes away, that account is not closed at all, not for 1 minute. So if someone passes away and there are multiple people's names on the accounts, the account is still going to be open and the survivors are going to be able to access the money at will.
Okay.
Well, typically they're going to be and, not and or. So I've never seen. But financial accounts are not set up that way. Sometimes checks are printed that way, but financial accounts are not set up that way. Financial accounts are set up typically in one way if there are multiple people on the accounts, and that's as joint tenants. That means if multiple people are on the account, one or two or three or more, if one of them passes away, survivors still have 100% access to the money. And so there is no case where there is multiple people on the account and one of them passes away and the survivors whose names are on those accounts cannot access the money. If someone is named a beneficiary on those accounts as opposed to be a signor on that account, then yes, presumably that account would be closed, and then the beneficiary then would have to wait until a death certificate were had to go in to make a claim to collect the money.
Oh, okay. What is the best way to get a title of a car to a son or daughter when I die? Add the son or daughter to the title before I die? What if I die suddenly before I add the son or daughter to the title?
Well, typically for me, particularly for my more senior clients who have cars that are paid for, I typically advise them to sign the title and put them with the other estate planning documents. If you happen not to have signed, and then whomever's going to be entitled to the car at the appropriate time will sign their name where it says where it says buyer, and then they'll sign it, take it to the Secretary of State's office, record it, and then they get the car very simply without having to go through some expense. If a person passes away and they have not signed the title, then you can go to the Secretary of State's office and they have an affidavit that one can sign that then will transfer the car to the heir. Okay, if the car is not paid for, you can't do either of those. And if the car is not paid for, no one else has any liability for the car, so you don't have to pay for the car. You're not going to be able to call the finance company and tell them to come pick the car up because they're not going to do that either. And so you can just leave it, and at some point they'll pick it up, or you can continue to pay for it, and then the Secretary of State's office, they have a process to get then the title transferred to the name of the heir, but the finance charge would still be in the name of the person that's deceased. Typically, I advise my clients to not date it because you may want to go buy yourself a new sports car, and you would just date it at that time.
Okay. This is a very good question. Does the toady override any wishes in a will or trust for a home? And yes, the question is, does a toady or a transfer on death instrument override any wishes in a will or trust for a home? So in other words, if you have a will or a trust and you also file a toady, what happens? So the answer is the toady controls. Even if you have something in your will, and think of it this way. If you have a will, in order for you to actually complete the transfer, you have to go to probate court, and the court will do it at that time. With a Toady, as soon as you pass away, your beneficiaries are entitled to the property. They just have to file the acceptance form with our office.
May I address that as well? It's a similar situation with financial accounts. If you have a will and you name someone to collect money by way of a will and you have beneficiaries on your financial accounts, the beneficiary is going to be successful in collecting the money. Let's talk about wills for a second, because I do a lot of these speaking engagements really all around, and wherever I go, there's one thing that I find that everyone have in common, and that is people believe that if they have a will, that's going to keep their things out of probate court. Please, let's be clear about this. If you don't get anything else from Ted London here, just please know this. If you have a will, your loved ones are going to have to go through the expensive, stressful, time-consuming probate process. A will not keep your real estate or your money out of probate court. I have not done a will for my clients in over 20 years because my job as an estate planning attorney is to help them avoid the expense, stress, time of probate court. Okay, probate court can be a very expensive process. And if your family members start feuding, it's going to really be pricey. So you can avoid all of that by doing some straightforward estate planning. One way is to do a Toady. That's going to be sufficient for some of you. Other of you need some sort of trust. But if you own real estate, if you have money in your financial accounts, you need to have some estate planning. If you have it in a will, if you name your loved ones to get your home and your money in a will, just know they're going to have to go through the expensive, stressful, time-consuming probate process. And really, the lawyers benefit as much as your children. I would not do a will for my clients, period.
And just to explain, people might be thinking, well, why the will then? Well, what a will does is basically sets out what your wishes are when you die. And in order to effectuate that, to make that happen, you have to go to court and have a judge, rule on it. You're basically setting up your own estate plan that gets put into the probate court. If you don't have a will, you still have to go to probate court. You just don't get to have a say what happens with your assets. It just gets decided for you by what's set out in state law. So if you don't have a plan, the state has made a plan for you, is the difference.
Unless you have some sort of trust. If you have some sort of trust, you can name who's going to get your real estate, who's going to get your money, and you're going to name who's going to manage it after you. And it's going to be without legal fees, without court costs, without bonds, without confusion, without a lot of time. Most of you in this room, you need some sort of trust for your financial accounts and for your real estate.
The form, the transfer on death instrument form, is a form that is used. You complete the form, you file it with the Cook County Clerk's office, and it would be in your chain of title. And when you pass away, your beneficiaries could file an acceptance form. And when they do that, then they would be the record owners of the property. You wouldn't have to go to probate court to do that. Sometimes, attorneys are used to what they're used to. And I will say that the transfer on death instrument, although it is relatively new, I think 2012 or 2011 is when the state legislature passed the Transfer on Death Instrument Act. Sometimes people aren't aware or just not used to or using that type of thing. So. You don't have to do that. You can have both husband and wife sign the Toady form. It's not going to affect the interest of the remainder. So say you and your wife have a Toady, you have beneficiaries. Unfortunately, you pass away. Your wife would still have, she'd still be the owner because she's a joint tenant. And then after she passed away, then it would go to your beneficiaries.
Yeah, well, I'll say this. It's much less expensive than going through the probate process. I'll tell you that much, by far. And you're going to make sure that you accomplish really what your objective is, because you can really customize it. Okay, so bottom line here is no wills. If you have a will, your loved ones are going to have to go through the expensive probate process. And most people wrongfully believe that if they have a will, that will keep their things out of probate court. And interestingly enough, even those who believe that don't even have wills. Okay, so, but the bottom line is no wills, because again, that's just an expensive, time-consuming process that you can avoid.
And I think this question is related to what we've already been talking about. It just says if you have a trust / will, we already talked about wills, but if you have a trust, does a payable on death account override it?
If you have a trust, no, the payable on death, the beneficiary is going to always supersede a will or a trust, period.
Okay. So the next, there's a question. So the purpose of the Toady is to avoid probate. Now, what this brings up an important point. If you do a Toady, make sure you tell your beneficiaries that it exists. Because if they don't know it exists, they're not going to file the proper documents with our office to accept it. And if you don't accept it, it's just going to be out there for an extended period of time. And eventually, if no one claims it, it will have to go to probate. So yes. Well, this is relating to your real estate. There could be other assets that you have. I don't want to speak like I know your specific situation, but the purpose is to keep the property out of having to go through the probate. A lot of people, their home is their number one asset for most of the people in this country. And if you have less than a certain amount of assets outside of your home, you could file a small estate affidavit with the court and or with other entities and collect the benefits of those accounts. But the transfer on death instrument relates specifically to real estate, your number one asset. And if you can keep that out of probate, there's a decent chance for the average person that you won't have to go to probate. No, I think you would just include both pins on the document. So I mean, I know the document that we provided here has only space for one pin number, but you could easily just attach a page to it and have 2 pin numbers on it.
You know what? May I add one thing about the Toady? Some of you are probably going to do Toadies, but I would advise you against preparing the documents yourself, because if you prepare them incorrectly, when your loved ones need them, they're going to be invalid. So, listen, we have legal aid here. They'll do them at no cost. If you're going to do a Toady, I think legal aid would do them at no cost for you. So whether you are entitled to legal aid, or whether you have to go to your own private lawyer to prepare the Toadies, it's worth the expense, because I've seen Toadies prepared incorrectly and that they are invalid. So one missed box and it can invalidate it, and it will send your loved ones through the dreaded probate process. No, there is no, they just have to go with a death certificate. And really, they don't really have to do anything at all. That's not, well, the experts are saying that they don't believe that there is any time limit. I don't think that there is, no more than there is a time limit on beneficiaries on your financial accounts. If you name beneficiaries on your financial accounts, even if they don't collect them within 7 years, if it goes to the state, that named beneficiary is still going to be entitled to the money. I presume the same thing is with the Toady. That's a great question. I've never been asked that question before. Yeah.
Okay, we have a question about property fraud alert. If we receive an alert that our deed has been purchased by a stranger what happens then? And I'm assuming you mean you find out that someone actually purchased a copy of your document, or someone, the person who, they, okay. So if someone purchases a copy of your document, the documents are all public records. Anyone could buy a copy of any record that's public record in our office. Okay. So I think the question is, what happens if they record a document on your property? Yeah. I think I mentioned before, you would have two options. One, some people would prefer to hire a private attorney to go into court and do a quiet title, or our office has a property fraud unit, which will go and represent, on your behalf, go in and file something in administrative review where we go in front of an administrative law judge. Yeah. So that's what we would end up doing. The question is there anyone that functions as a professional executor?
That's another question I haven't been asked before. I don't know, but I presume that there are some firms that for a fee you can have named as the executor of one's estate. Yes. Could be lawyers, yes. But probably not the lawyer that does your estate planning. That's probably going to be a conflict of interest. But he may have a partner or someone that he works with or she works with that you could have appointed as the administrator or an executor, or as a trustee in a trust, because we still prefer a trust over a will.
Yeah, my understanding is if you have a will, you designate an executor in your will. If you don't have a will, you die intestate, then the court appoints an administrator of your estate on your behalf. I understand. So you're wondering if you can just find someone and say, I want you to be the executor of my estate. Understand. Okay, the next question. Does the property fraud alert prevent your home from being stolen, or does it just alert you to someone filing a fake deed? You want to answer this one, Kang?
So the property fraud alert does not act as like a credit freeze. All it does is it alerts you to a document that's been recorded and then indexed against your property. And I want to remind everybody here that the vast majority of the alerts are received by people who actually triggered the alert themselves. So they add a family member to ownership and they record a quitclaim deed and it's theirs, or they put property into a trust and that triggers an alert. Sometimes I actually do get customers, taxpayers like yourselves, calling, and they, because of all the paperwork that goes into creating the trust, are unaware that this would have triggered such an event. And then when we explain it to them, it's like, oh, okay. So that's the first category. That's the vast majority of what triggers an alert, are actions that you take or actions that your bank took, right? So you do a refinance, for example. You'll get that alert. All right, so that's one category. The second category are documents that are misindexed against your property. That can happen, right? It's a Friday afternoon and a 5 looks like a 6. They type that in and it goes on your PIN number. Give us a call, let us know. We'll look at it. All right, so, and then at the very minority are the bad people. And we'll look at that with you, definitely.
May I add one other thing about your deeds? You have to be mindful of your deeds. Here's what I find in my office often, that at one point there was a husband and wife's name on a deed, and for whatever reason, one of their names was taken off of the deed. And then sometimes they never add the person's name back to the deed. And then if that person passes away before the other person passes away, then the estate's going to have to be probated. Here's what we see as well. If two people's names have been taken off of a deed, oftentimes this is done if homes are being refinanced and only one of the spouse's names. And then they'll put the home back in both of their names, but they don't do it as joint tenants. They do it as tenants in common because perhaps they've done this deed themselves and they did not add the language. And that means when one of those spouses passes away, their half must be probated. So you want to make sure if you're married that your deeds are, if they're in both of your names, that they are in joint tenancy. And how do you know if your deed is in joint tenancy versus tenancy in common? Because it's going to say on the deed itself, husband and wife as joint tenants. That means if one of you passes away, whoever survives automatically owns the home. If you don't see that language on your deed, and again, gentlemen have told you how you can access the website, get a copy of your deed, it's free to do. Then if you don't see the joint tenancy language on your deed, it is not in joint tenancy, it is in tenancy in common. And then if one of you passes away, that person who has passed away's share is going to have to be probated. And then if the second spouse passes away, presumably both of their estates are now going to have to be probated by the children to get the whole of the house to the heirs. It can be very, very pricey. So make sure you're double checking your deeds to make sure that both your names are on the deeds as joint tenants.
Okay. The next question. If married but separated for 5 years, can spouse get your property and bank accounts? Do you need divorce for how many years? Can children be entitled?
Well, another fairly common issue. People get separated and not divorced. And so if people are separated and not divorced, then if one of them passes away, if there is no estate planning, the surviving spouse is going to get half of everything. Even after a 20-year separation, I've seen it. The surviving spouse is going to get half of everything. And so the bottom line answer to the question is yes. If you are separated but not yet divorced with no estate planning, then yes, that spouse will get half, because the spouse will get half and the biological children would get the other half, and they would divide that equally.
Okay. Another question. My father passed away in 2020. We just realized he did not put another name on the vehicle title. How can we put another name, like my mom, on the title of the car?
Again, there's a process that, and it's called a small estate affidavit, and you can access that on the Secretary of State's website. It's free to do. So you just download it, fill it out, and take the small estate affidavit from the Secretary of State's website, along with a death certificate, to the Secretary of State's office, and then they will transfer the title from the name of the husband to the spouse.
Okay. Here's we take for granted that the terms are explaining, but it's not the case. So this question is very important. Is title the same as deed? Because you hear us referring to title and you hear us talking about deeds. So basically, when we talk about your chain of title, the chain of title is just the history of what has happened on your property. The deed is actually a physical document that you receive that shows your ownership in the property. So when you purchase a property, you generally get what's called a warranty deed. There's quitclaim deeds, trustees deeds, different types of deeds. The purpose of the deed is to transfer a property from one person to another. Now, the history of your property over the course of the years, it'll show all your mortgages, liens, deeds, everything that has happened in your property since the day your property was first subdivided is in your chain of title. Now, there's different types of title. There's car titles. A lot of people think of deeds just like car titles. Like you don't have the title of your property until you pay off your mortgage. That's not the case with real estate. Real estate, when you purchase your home, you get a copy of your deed at closing. That is your proof of ownership in the property. Now, if you don't pay your mortgage, the mortgage company could file a foreclosure action and try to take the property away. But it is your property, unlike a car, where you have to pay the car off and then you finally get your title in the mail afterwards. With real estate, you pay your mortgage off, you get what's called a release of mortgage. That just tells the world that the owner of the property has paid off the mortgage and it's free and clear from any outstanding any outstanding liens or mortgages, I should say. So you would get the deed when you close on the property, but if you don't have a copy of it, it's common that, you know, you forget where you put it or wherever. We have copies of all those things in our office and our public records. So you can either buy a copy online or come to our office or reach out to our office, and we could assist you in getting a copy of that document. Our office, the Cook County Clerk's office. Okay. Here's another question relating to property fraud. How often do you need to check to see if there's no fraud going on with your property? Okay, do you want to take that one?
Well, it's really up to you. Number one, sign up for the fraud alert. Okay, do that for yourself. But definitely familiarize yourself with how our website works because it's free. You pay for this. You know, you're all taxpayers. You pay for these systems that we put out there for you. So familiarize yourself with it. Look up your PIN. Familiarize yourself with what's in that chain of title. You know, so you're familiar with, oh, okay, this is what happened. And from there, you know, every now and so often, have a look at it. Definitely.
You know what, Ed? You know, the property fraud alert, the way it works is if there's any document recorded on your chain of title, which is generally indexed by your PIN number, you'll get an email or phone call, however you decide to be notified if anything's been put on there at all. Just because you get an alert doesn't mean that there's something wrong. You could have just refinanced and the refinanced mortgage ends up recorded with our office. You might get an alert, but at least you know, oh, I just refinanced my property. You could look online and see, oh, yeah, that's exactly what that is. We're just trying to give you information so you can keep an eye on what's going on. Sure. Sometimes, yes. That's a complicated question because there was this, for a long time, they had what was called MERS. So that's basically the electronic recording system for mortgages. A lot of times banks will sell your mortgage over and over again, and they didn't want to pay the recording fees. So what happened was they created this entity called MERS, where you get a mortgage, they'll immediately set it over to MERS, and they don't have to notify our office if they sell your mortgage. Now there's several recorders' offices throughout the country that fought that, but at the end of the day, it was ruled that they were able to do that. So the answer is maybe. In most cases, they might not do that. But some banks might want to do it just to clarify that they're the owner of the mortgage in case they need to do something later. If there's a foreclosure action, there always is going to be something filed by the bank that's trying to get the property. That I promise you. But a good question. Another question, if a parent who is living is on my bank account, can the money be taken as an asset if they need health care?
Hey, I was waiting for that question. I'm surprised no one inquired about that. So really what the issue is Medicaid. The issue is what's called a Medicaid spin down. And that is if someone goes into a nursing home, is Medicaid going to take their assets? And so the answer is if one is not what's called a self-payor, if you're not going to pay that $6,000, $6,500, $7,000, $7,500 per month nursing home costs, then Medicaid is going to do what's called a Medicaid spin down. They're going to come in and they're going to get control of your home. They're going to take control of your financial accounts, and they're going to use your money to pay for your care before they start paying for your care, Medicaid that is. That's called a Medicaid spin down. And so if a couple is married and one of them goes into a nursing home and they need the benefit of Medicaid, Medicaid will not take the home, and they will allow the non-Medicaid spouse to retain up to $160,000 in assets. So you'll be able to keep the home and up to $160,000. If a person is single and they need the benefit of Medicaid, then Medicaid will only allow them to keep up to $2,000. And they will take the home and they will take the assets to pay for your care before Medicaid chips in to pay for the care. Okay, so again, the issue is what's called a Medicaid spend down. The research suggests that over half of all people over 65 years old or older will spend some time in a nursing home. And as we age, then the percentage rate goes up in terms of who's going to spend some time in a nursing home. So many Americans are spending time in nursing homes. And so the issue is who's going to pay for it. Nursing home care is very pricey, averaging between $6,000 and $7,500 per month or more. Okay? And so the issue is who's going to pay for it. Well, if you can pay for it yourself, many people can. They have pensions, Social Security, and that will cover that $7,000 a month health care cost. They have no concern about a Medicaid spend down. Others may not be able to pay that $6,000 or $77,000 per month, but they have assets, real estate, financial accounts. Well, Medicaid will then collect your real estate and collect your financial accounts to pay for your care. I've seen them usurp hundreds of thousands of dollars for individuals to pay for their care because people are living longer and sometimes they need specialized care that only a nursing home may provide. And so they will take your resources to pay for your care. And then once the value of your resources have been exhausted, then Medicaid will come in and pay for that care. Now, if someone is married, they will not take the marital home, and they will allow the non-Medicaid spouse to keep up to $160,000. If someone is single and they need Medicaid, then Medicaid is going to allow that person to only retain $2,000 in assets. There is what's called a 5-year look-back period. That means you cannot transfer your assets out of your name or control within 5 years from the time that one would need Medicaid. So if you need Medicaid next year and you think you're going to transfer your home out of your name, your financial accounts out of your name into the children's names or someone else's name, Medicaid is going to discover that because they're going to do a look back over the past 5 years of all of your financial accounts and see what you have transferred out of your name and control. And if you have in fact done that, then Medicaid will then preclude you care for the amount of time that those funds would have covered. Well, there are some expenses that are qualified expenses, funeral expenses, other expenses, for example, that you can use the money to pay for that Medicaid will not discount against you. But other than that, if you start transferring large sums of money or any sums of money, Medicaid is going to disqualify you for the amount of time that those funds or resources would have covered. That sounds accurate. There is a distinction between Medicaid and Medicare. I am referring to Medicaid. Medicaid typically applies if someone goes into a healthcare facility for long-term care, typically over 100 days. Well, good question. So her question was, what happens if Medicaid gets control of your real estate and your financial accounts, and the person, typically, they don't go home because they require specialized care. So let's just presume the person passes away. Theoretically, you would think that Medicaid would refund the money, and they may refund a portion, but by the time the lawyers are involved, expenses, there's typically very little.
I just want to make a point that we're running. We've had a lot of good questions. We're running out of time. We have about 5-10 minutes left, so I'm going to try and burn through a lot of these questions as quickly as we can. I'm trying to put aside the questions I've kind of heard that we've answered already. So if you don't mind, I'm going to just start buzzing through some of these questions. So, question: I have 4 children listed in my IRA accounts. Do I need any other documentation?
If you have them listed as beneficiaries, you do not need any other documentations. They do need to know where all the accounts are, because even if a person has beneficiaries on all the accounts, if the loved ones don't know where they are, they cannot collect the money. It's getting a little bit more difficult for them to find the money because some of you are using online accounts. So make sure that the loved ones know where the accounts are. You parents always think the kids know where the accounts are. The kids don't. Make sure they do.
Okay, next question. My husband and I did a trust years ago, but think the attorney may not have filed it. How do I find out if it was filed?
Trusts don't need to be filed, particularly if they are living trusts, but you want to make sure that the assets are recorded into the trust. So you want to make sure that the home is titled in the name of the trust, and your financial accounts are either titled in the name of the trust, or the trust is the beneficiary of your financial accounts. So the trust itself doesn't need to be recorded, but the real estate needs to be recorded into the trust. I've seen many times people have trust and the assets are not recorded into the trust, and once the person passes away, those trusts are void. You have to make sure the home's recorded and the financial accounts are either titled in the name of the trust, or the trust is the beneficiary of those accounts, and then the money will roll through the trust once the person passes away.
Okay. Shouldn't a checking account or savings be open that has the deceased name just in case a check comes in after death so it can be deposited? Because we couldn't cash any checks made out to the deceased that was received afterwards.
If there's a check made out to the deceased after they have passed away, then you can use what's called a small estate affidavit to send the check and the small estate affidavit form back to the supplier of that check, the provider, that institution, and then they will rewrite a new check payable to the name of those listed on the small estate affidavit document.
To get my house to my son or daughter without going through probate, what do I do? Land trust? Transfer on death deed? Does Toady apply to all of state of Illinois? The answer is yes, it does apply to all of state of Illinois. Transfer on death instrument, as I mentioned, does allow you to transfer real estate without going through probate. And land trusts also do the same thing, just in a slightly different way.
And it has the land trust and other trusts have a number of other kinds of benefits, respectively, the Toady doesn't. There's a privacy benefit when you have your property in a land trust, where if someone researches your name, they're not going to see what you own. If they research your home, they're not going to see who's the owner. It stops judgments from attaching to your home as well if you have your home in a land trust. And it also cuts down on property fraud as well. So Toady is a good thing. But some of you may need a land trust because the land trust does offer some benefits, frankly, that the Toady does not. There is an ongoing fee for a land trust. If it's a living trust, there is no ongoing fee. Oftentimes, when people come in to my office, the primary objective is to see what they're trying to accomplish, and then we can determine really what's going to be best for them. Typically, they're going to be done by attorneys, yes. Chicago Title Land Trust is the largest trust company in the country. They don't do trust documents, but they are the holder of the trust, but they don't prepare the documents.
Okay. Do you have transfer on death instrument forms here tonight? I don't want to go downtown. Where do I go? I can't say that I blame you. But what I will say is we do have copies of the forms here tonight. Unfortunately, we can't record them here tonight because there is a fee associated with it. It's $50 for recording a transfer on death instrument. And if you mailed it in, we could record it for a $5 fee. But I talked with Assessor Hines tonight. We're going to work out a process to where we can work together and collaboratively to help residents of the township get their documents recorded with their office without having to go downtown.
And again, if some of you may qualify for the legal aid, they're free. So if you're going to use the Toady, if you qualify for the legal aid, why not take advantage of them? They're here and it's free. So consider that.
How do I make sure my beneficiary can access my safety deposit box?
Great question. So if you don't have, who still has a safety deposit box? Most of the people that I know don't really need one because the only things that are in them are old papers. And so when your loved ones, when you pass away, your loved one's going to think you have $1 million in there. Mm-hmm. You know, they already think that anyway, right? And so, but if you want to make sure that your loved ones can get into the safety deposit box without them having to go through the probate process, because if you have a safety deposit box, what they'll do is they will allow your loved ones to go in to see if there is some estate planning documents in there. And if they are not, they will close it up, and then your loved ones have to go through the probate process to access it. just to get some old papers. So if you have a safety deposit box, make sure you have someone's name on it so they can access it once a person goes to heaven, if you will.
This is a common question I'm seeing in the cards. No computer, smartphone. How do I get a copy of my deed without having to go downtown? Once again, we don't want to go downtown. You could get a copy from our office. Without having to go downtown, I suggest giving us a call. You can call our property fraud unit, 312-603-4000, and our property fraud investigators will be able to help you get a copy of your deed without having to go downtown or online or anything that is a pain in the rear. Yeah. Okay. This sounds like a big one, but okay. Kids in all the accounts. Child goes through big divorce. And I'm guessing this is the person, is she entitled to his share of my child's money? So I'm guessing your child is a son and the ex-wife is the spouse.
Question is, someone's getting divorced, their names are on their parents' accounts. Are those proceeds going to be part of the divorce matter? Likely. Yeah. Now there can be some fights about it in the dissolution proceedings, but you know what that's going to be? More lawyer fees. So another reason why you don't, we just talked about that at the beginning. You do not want your children's names on your accounts because it's subject to judgments, divorces, who knows what. Beneficiary is going to be sufficient to transfer the money to them once a person goes to heaven. Yes.
Okay. Is it a problem if the executor of your estate is from another state?
You know, you can have, if there is an executor named in a will that lives out of state, that's going to be fine. But again, we want to move away from those wills because that calls for probate, legal fees, filings, lawyers, time, fights. You can avoid all of that by having some estate planning, talk to your estate planning lawyers. With a living trust, you don't need a will as long as the assets have been transferred into the trust, the real estate and the financial accounts. Those are the two primary things ordinarily that we want to keep out of probate court, the real estate and the financial accounts. As long as they are transferred into the trust, that's going to keep those things out of probate court.
Okay. Final question. If you haven't paid your real estate taxes, will you get a fraud alert? The answer is no, because if you haven't paid your real estate taxes, there's nothing filed on your chain of title.
So if you don't pay your real estate taxes, there's these groups out there that will, quote unquote, they're called tax buyers. They'll buy your taxes, they'll take your property, and if you do get an alert, it's because they're suing you and they're going to take your property. So, you know, make sure you pay your property taxes. The Cook County Treasurer's Office's website, they have a website. You can look on there. If you go to our website, we have a tax delinquency section of our website. You can actually type in your property index number and you can look that up. But again, really important that you pay your property taxes.
Yes. That's a great question. And just to let you know, the Cook County Clerk's Office does not have anything to do with when the tax bills come out. But from what I understand, the Board of Review is still hearing some appeals on property taxes for this year. And then once that's done, they send that back to the assessor. The assessor calculates everything and sends it out. Hopefully before the end of the year, because I know a lot of times people pay their taxes and then they deduct that from their income taxes the following year. So our goal as a county, I know several agencies have indicated that they want the tax bills to go out so that they can be paid this year so that the folks that pay it can deduct that from their income taxes next year. Legal Aid Chicago. The question is, how do you know if you qualify for free legal aid?
So if you are a senior over 60 years old living in Cook County, you will qualify for all of our services for free. If you are under 60, we do have some income guidelines that we can talk to you about individually if you'd like to come and check with us. It's typically 150% of the federal poverty line for your income. We can figure out if you qualify or not. But again, if you are over 60 living in Cook County, all of our services are free, including the transfer on death instruments. We are located in the Loop, but we do these appointments over the phone. You can come on over here. We've got all the forms that you'd need to give us a call.
That is all the questions we're going to be taking. I'd like to thank everyone for coming to this presentation tonight. You guys have been a fantastic crowd. If your question wasn't answered, feel free to reach out to our office. We'd be happy to work with you and make sure your questions do get answered. The property fraud alert documents can be turned in today. And there's one more thing that Brian Cross and I think Assessor Hines want to talk about. So if you just stay put for a second.
Well, first of all, I'd like to thank you everyone for coming tonight. I'd like you to just take a moment. These were great questions tonight, really deep, detailed answers. If you guys could just take a moment and give a round of applause for these folks who donated their time to come out here late tonight. I really appreciate it.
Again, we want to thank Pat. Pat has been a wonderful, wonderful host. We hope that you guys learned tonight. We thank our attorneys, as Pat said. If you wish to host your community, Ms. Robin Stagger at 312-603-3974. Real quickly, too, if you have any friends who want to go to this presentation, we're going to be up the road on Tuesday, October 1st in Oak Lawn at the library, same time, 5:30 to 7:30. So please tell your friends, and thank you very much. We greatly appreciate you, and have a safe ride home.